man up slaves and hit those buttons, or I'll send ice.
Hold up, grab my soda, cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got the smell, you know, like grape ape. We ain't talking vapes or the color of drapes. Or a gorilla in a cape is the good shit. Just one hit, you so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation with gross castration, S.W.A.P, citations by your intimations. Get real, young man, there's only one stand. You can't stand a suntan, how you gonna live on the land? Obliteration of the carnation with gross castration in skewed citations by your intimations. I'm a truth in rotation, you're a cheap imitation. Dark said hums, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in the cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna click another hit of this good shit, and I'm already it, so take over this bit, non-bit.
Thank you for joining us at Personality Inventory Mockumentary Productions.
Greetings, everybody. Hope everybody's having a good day, enjoying life, living life, loving life. I want to remind everybody, hit those buttons, like, share, and subscribe. There's a PayPal link down in the details section for anybody who wants to share some love. Always appreciated. And let's get into it. For those that don't know, we're currently going through an eviction, and of course, it's a wrongful eviction. And I am assured that we will win because we are right, we are correct, and it may take appeal and, of course, follow up with a civil rights claim. But tonight, I'm going to go over some paperwork in preparation for yesterday's hearing, because I expected either an award to the property management for the eviction or a dismissal, and the judge instead took it under advisement for a week or so and will get back to us. So we're pending the decision from the magistrate, actually, not a judge, but a magistrate. And so I'm going to go over my preparation for emergency stay of execution pending the appeal, and of course issuing an appeal. So let me get into that. The StreamYard link is pinned for anybody that wants to join the panel. I am going to go over this paperwork first, and then I'll open the panel for anybody who wants to have discussion about it. And I would hope that people will hit that link, because this is something that is prevalent amongst the common people to be evicted. And I think many of them are wrongful. And I have information in my own case that would behoove you to do your research. Like I've said, don't believe me, don't believe the neighbor, don't believe the government, for crying out loud, don't believe your mother. Do your research so you know, because this is the inherent part that most business people lack. They will go to an attorney rather than do the research and know themselves. And this is the pertinent point in our case. We have 3 points of discussion, and one is that the property manager admits that they've been doing property management for 8+ years, that they did not issue a notice, a 7-day notice to cure once we gave them a complaint about a noise issue. And they also did not know that they have a strict statutory duty to do so. And so we're going to go over this information. And of course, anybody that's taking notes, this is in the Iowa District Court of Black Hawk County against MGT Property Management, which is the plaintiff in this situation at the point, versus Keith Little and Joyce Schmidt, defendants. The note you would take would be case number SC 200826. You can look that up on public records information here in Iowa, Iowa Courts Online. And what I have is a motion for emergency stay of execution pending appeal. Comes now the defendants Keith Little and Joyce Schmidt, and respectfully moves this court for an order staying the execution of judgment for possession and writ of removal entered on. And like I said, they did not execute, grant a writ of execution because she wanted to take it under advisement. And so we'll be hearing back on that in about a week. So pending the final resolution of defendant's appeal. In support of this motion, defendant states the following: statutory grounds for stay. Defendant has filed a timely notice of appeal pursuant to Iowa Code 648.15 to preserve the status quo and prevent irreparable harm. The court has the inherent and statutory authority, and I would say duty as well, to stay execution of the judgment under Iowa's Rule of Civil Procedure 1.1006 and Iowa Rule of Appellate Procedure 6.601. Irreparable harm to disabled tenant, and this is in regards to my companion who has both physical disabilities and mental disabilities, namely dementia. Defendant is a person with a documented disability, specifically dementia and other physical disabilities, as defined by the Iowa Civil Rights Act, Iowa Code Section 216.2, subsection 5. Physical danger, eviction, and subsequent homelessness pose a clear and present danger to the defendant's life. Persons with dementia suffer from transfer trauma or relocation stress syndrome, where sudden displacement leads to a rapid cognitive decline, increased risks of falls, and elevated mortality rates. The medical necessity: defendant requires stable housing to manage life-sustaining medical care. Homelessness would deprive the defendant of the climate-controlled environment and sanitary conditions necessary to prevent exacerbation of her condition. Civil rights violations and procedural errors. Violation of fair housing laws. Under Iowa Code 216.8a, the Federal Fair Housing Act, and the Federal Fair Housing Act, the landlord had a duty to provide reasonable accommodations. Defendant contends the landlord failed to accommodate the defendant's disability regarding noise and other issues, and the current eviction is a direct result of that failure. Statutory breach of duty. The landlord is in material breach of Iowa Code 562A.15, maintenance, for failure to maintain a safe and habitable environment. The trial court committed a prejudicial error by awarding possession to a landlord with unclean hands, who is in active violation of health and safety statutes. So what we're saying here is, if that decision comes back in a week and they grant the writ of execution, they have made a procedural error. If they come back with a dismissal, then we move forward with our civil rights claim. Request to waive or set reasonable bond. In any kind of appeal, you're required to provide some kind of a bond in case the plaintiff would lose any kind of income because of it. but we are asking that that be waived. Defendant requests the court waive the supersedeas bond requirement or set it at a nominal amount, as the defendant is an indigent and a high bond would effectively deny the defendant's constitutional right to an appeal. Justice is not for sale, denial, or delay. Wherefore, defendant respectfully requests that this court immediately stay the execution of the writ of removal, allow the defendant to remain in the premises pending the outcome of the appeal, waive or set a nominal appeal bond in light of the defendant's disability and financial hardship, and of course, placed a date and sign. So that is the motion for emergency stay of execution pending the appeal. And then, of course, we have to timely file that appeal. So we have a notice of appeal and statement of errors. Again, under small claims, S.C. 200826. Notice of appeal and statement of errors comes now the defendants, Keith Little and Joyce Schmidt, and hereby appeals the judgment for possession entered by the magistrate on such and such a date, if they grant that writ of execution, to the district court. So we're in small claims court now, and it's being administered by a magistrate. So we would appeal to a higher court, which in our case wouldn't necessarily be the state court, but the local district court. So it's to enter it into the district court, removing it from the small claims court. If you try to do this in the small claims court, you're limited to punitive damages, and Iowa has a maxed out of $6,500. And that means we would get $6,500 at the expense of the property management, but we wouldn't be allowed actual damages for emotional distress and stuff, which we're going to be asking for $25,000. Very, very reasonable amount in that in a civil rights claim. Statement of errors. The defendant asserts the magistrate committed the following prejudicial errors of law and fact: failure to apply mandatory statutory notice requirements. The magistrate erred by granting an eviction despite the plaintiff's failure to provide a 7-day notice to cure for a noise complaint as required by Iowa Code 562A.27, subsection 1. Strict compliance with notice is a jurisdictional prerequisite for a forcible entry and detainer action. And that is, the first duty in law is legal notice. We gave them our legal notice through a noise complaint, and by their statutory duty, they failed to give the upstairs tenant notice that they needed to quiet down, which allowed the situation to be to escalate. And now they're trying to evict us under a clear and present danger, when they're the ones that provided a clear and present danger to myself and my companion by not following that statutory requirement. Failure to recognize retaliatory conduct. The magistrate erred in failing to apply the presumption of retaliation. There is a presumption of retaliation if you're evicted within a certain time after you make a complaint to a landlord. In Iowa, it used to be 6 months. Now it's a year. This has been less than 1 month. So it's most certainly retaliatory presumption there. Evidence was presented that the defendant complained of life safety maintenance issues, specifically regarding a noise complaint, within 1 year of the filing. Abuse of discretion regarding disability protections. The magistrate failed to consider the defendant's right under the Iowa Civil Rights Act, section 216.8A, as I mentioned earlier, and the federal Fair Housing Act. The court ignored evidence that the landlord failed to provide reasonable accommodation through a 7-day notice to cure to the upstairs tenants for a person with dementia whose health was directly endangered by the landlord's maintenance failures. Error in clear and present danger, which is the statutory code that they're trying to use against us to evict us. The magistrate misapplied Iowa Code 562A.27A by failing to recognize the landlord maintained a hazardous environment, a chaotic environmental nuisance from the excessive noise upstairs that constituted a danger to the life of a disabled tenant. Request for de novo review on the record. Defendant requests that a district court judge review the record of the proceedings below and reverse the judgment of the magistrate. Prayer for relief. Wherefore, defendant respectfully requests that this court set aside the judgment of the magistrate, dismiss the petition for forcible entry and detainer, and award any other relief the defendant's request or that the court deems reasonable attached hereto. And then, of course, dated and signed. And then we have the prayer for relief attachment. Wherefore, the complainant defendant respectfully requests that this court enter a judgment in their favor and against the respondent plaintiff for the following: permanent injunctive relief, enjoining the respondent from proceeding with the wrongful eviction and compelling the respondent to perform their statutory duties under Iowa Code 5628.27 and 5628.15, which would be the notice of cure to the upstairs tenants and then the eviction following. Actual damages in the amount of $25,000 for emotional distress, mental anguish, and the exacerbation of medical conditions, dementia, caused by respondents' failure to accommodate and wanton disregard for complainant's safety. Punitive damages in the amount to be determined by the court to punish the respondent's admitted intentional ignorance of the law and deter such future conduct in the amount of $6,500. Costs for costs of this action and any other relief the court deems equitable. And then we have the Iowa Civil Rights Complaint. Housing discrimination complaint, Keith Little and Joyce Schmidt. Respondent, MGT Property Management Company / Listy Wickham. Basis, disability, 2 knee surgeries, multiple foot surgeries, and what's known as frontal temporal dementia. If you guys are familiar with Bruce Willis, the famous movie actor, that's what he has. It's the same thing. And like I said, they go through various different emotional stresses, particularly in consideration to excessive noises, relocation. They're used to an environment, and if you relocate them even to another peaceful environment, they go through great amounts of stress. Trying to go out and look at places while we try to prepare to move, my companion gets very fidgety and emotionally scared and traumatized. It is very real. And I'm the one that has to put up with those consequences. I'm the only outlet she has. So again, when the landlord fails their strict statutory requirement, their duty to issue a 7-day notice to cure, that is the epitome of ignorance of the law is no excuse. And like I said, this lady's been doing property management for 8+ years, admitted that she did not give a 7-day notice to cure, and admitted that she was not aware of the strict statutory duty to do so. And again, ignorance of the law is no excuse. Thanks to Jack Talcott and all of his people rating me now. I appreciate it. May you all be blessed. Drop by to say hello and subscribe. Good night. God bless. Thanks, Trexty. Appreciate it. Yes, we appreciate the raid. We've got Kylan LX80P says hello. Captain Action is here, one of my favorite guys. And so feel free. The link is pinned for anybody who wants to come up. I'm almost done, and I will open the panel for anybody that wants to go over anything. I have 10 more pages of notes we can go through. But the housing discrimination complaint, I continue. Failure to provide reasonable accommodation, Statement of protected status and good faith. The complainant is a tenant at 1334 apartment D, Waterloo, Iowa, and is a person with documented physical and mental disabilities, namely dementia, as defined by Iowa Code 216.2, subsection 5. At all times relevant to this matter, the complainant has operated in complete good faith, strictly adhering to all material terms of the rental agreement. We've been here 6 years and have never had any issues. And when we had a maintenance technical problem, we would call the old property management and they were dutiful, responding immediately with complete respect, and we appreciate that. However, the new management company that took over here recently, we've had all kinds of issues. This includes, but is not limited to, the consistent and timely payment of rent. We've never been late on rent. The complainant has fulfilled every obligation under the lease, expecting an equal performance of duty from the respondent. Now, before I go further, we have to remember that this is an equitable action in these courts, and therefore we are dealing with equitable principles. He who seeks equity must come with clean hands. Equity is a sort of equality. Equity does not aid a volunteer, and equity imputes an intent to fulfill an obligation. So when we paid rent, we gave consideration. That is not a voluntary act. We expect an obligation in return. That is an equal expectation that the landlord expects us to follow the lease terms. Since we were following the lease terms and they failed, and we gave them proper legal notice of the noise complaint, and they failed to follow their statutory duty to follow up with a 7-day notice to cure to the upstairs tenants, they are coming with hands as dirty as our furnace filter. The primary violation, failure to accommodate in regards to the noise issue. The complainant notified the respondent that excessive noise from a neighboring unit was triggering an emotional crisis characterized by profound emotional turmoil and cognitive decline. It causes her great amount of stress and confusion. And like I said, she can only take that out on me. I'm the one that has to deal with this. So I dealt with it by contacting the neighbor upstairs and asking them politely to quiet down. Did that several times, and they did not do so. Then I noticed the landlord. The landlord is required to give a 7-day notice to cure to them, and they failed. They admitted this on the stand. They did not give that 7-day notice. In that, they also said that being a property manager for 8 years, they did not know they were required to do so. And again, ignorance of the law is no excuse. I fully expect to beat this eviction. Under Iowa Code 216.8a, the respondent had a non-waivable duty to provide a reasonable accommodation to ensure the complainant's equal use and enjoyment of the dwelling. Specifically, the respondent had a strict statutory duty under Iowa Code 562A.27, subsection 1, the maintenance, to issue a 7-day notice to cure to the offending neighbor. The respondent's manager explicitly admitted to a total lack of awareness regarding this duty and failed to issue the notice. This is not a mere oversight. It is a refusal to perform a mandatory legal obligation intended to protect a vulnerable tenant. Pattern of reckless indifference. This is the equity argument, because out of chaos comes order. And in all of this disrespectful attitude of the manager, their chaos of not following the law will show a pattern of practice of not following the law. The respondent now seeks the assistance of the law to evict the respondent, the landlord, now seeks the assistance of the law to evict the complainant, us. Yet the respondent has failed to fulfill the very obligations that justify their status as a landlord. Imputing intent through action. The law assumes that a party entering a contract, this is a rent agreement, intends to fulfill their obligations. By failing to provide a habitable and quiet environment, the respondent has signaled a lack of intent to follow the Uniform Residential Landlord and Tenant Act, the standard of conduct. The respondent demands equality in enforcement of the lease against the complainant while maintaining a standard for themselves that is dangerously deficient. The respondent currently maintains a furnace filter that has been neglected for over 3 months, creating a fire and carbon monoxide hazard, and has also failed to clear snow, blocking physical access for a disabled person. Clean hands doctrine. One who seeks the protection of the court to remove a tenant must themselves be in compliance with the law. The respondent comes to this proceeding with unclean hands, seeking to punish a tenant who has paid considerable rent in exchange for safety and peace, while the respondent remains inactive, admitted violation of health and admitted violation of health and safety statutes. Inequity of aiding a volunteer. The respondent's failure is not due to lack of resources, but a voluntary choice to remain ignorant of the law. The court should not aid a landlord who voluntarily disregards their statutory duties while expecting a disabled tenant to suffer the consequences of that neglect. Conclusion and request for damages. The respondent's admitted ignorance of their strict statutory duty is evidence of a conscious indifference to the complainant's civil rights. In other words, willful and wanton neglect or disregard. Again, ignorance of the law is no excuse. By refusing to enter or to enforce the noise rules with a 7-day notice to cure while maintaining life-threatening hazards, including other hazards, the furnace filter not being replaced, the snow not being removed, the respondent has engaged in a hostile and housing environment through a pattern of practice. Wherefore, complainant requests an immediate injunction to stop the wrongful eviction, actual damages for emotional turmoil and medical decline caused by the noise, $25,000, and punitive damages to address the respondent's wanton disregard for Iowa civil rights, $6,500. And so there we have 7 pages for a emergency stay of execution or writ of possession, along with an appeal and along with the civil rights claim. Gosh dang it. And so the panel is now open for anybody that would want to join, and any questions that are out there. But I want to make it very important and clear here. This is why I speak out. Jack Talcott, you went through a wrongful eviction. I am sure of it. They violated your rights, brother. That's the only thing I was offering when we first met. The magistrate, instead of giving a verdict yesterday, they said that she said that she is going to take it under advisement. In other words, she's going to people that she doesn't know, because I made it specifically clear in questioning the landlord property manager, Listy Wickham, how long she's been a property manager. 8 years. Did she issue a 7-day notice to cure? No, she did not. Was she aware that she had a strict statutory duty to do so upon our giving her a notice of a noise complaint? And she said no. So again, ignorance of the law is no excuse. And this is where the willful and wanton disregard comes in. You cannot be a mechanic and be licensed to be working on somebody's car and fuck up the brakes because you didn't know something. See, ignorance is no excuse. If you're going to be a mechanic, you have to be able to perform as a mechanic and dutifully, because a vehicle is a matter of safety and health. Just like an apartment is a matter of safety and health. particularly for somebody that needs a peaceful environment. And there's excessive noise that is not conducive to their health. We gave the proper noise complaint. They failed their duty by statute, and now they're trying to use statutes against us to remove us when they're the ones that failed the lease agreement. So we're going to wait, she said, about a week, and we'll hear back. And like I said, we're only preparing in case she gives the award or verdicts to the landlord. But we fully expect that we're going to have a dismissal, and then we can move forward with our civil rights claim. I hope that makes sense. And like I said, you can look it up. Case number on Iowa Courts Online, case search, and then enter in case number, and this is for a small claims case, S.C. 200826. And I'm amazed that nobody clicked that link to come up. Because this is something that I believe is systemic and is pertinent to everybody. And yet nobody wants to come up and discuss it. That's amazing. So in the meantime, we're going to take a break and enjoy this short break. And then I'll be back, and hopefully somebody will click the link. And if not, then I'll make some closing statements, and we'll just hope the best. Let me start this over, folks.
The pines where the red clay cries, a preacher's words cut through the lies. With a Bible worn and a rifle tight, we march where the tyrant's shadow bites. Oh, freedom's flame burns through the night, a rebel yell for the righteous fight. Break the chains, let the truth be sworn, from dust and blood a new dawn's born. The widow sows seeds in her husband's field, her tears baptize the ground they'll yield. A soldier's ghost hums an old hymn's tune, we'll cross that river for the blood dark moon. Oh, freedom's flame burns through the night, a rebel yell for the righteous fight. Break the chains, let the truth be sworn, from dust and blood a new dawn's born. When the thunder roars and the levee breaks, we'll plant our flag where the despot shakes. Through fire and flood, we'll hold the line, for peace ain't bought lest we dare to climb. Oh, freedom's flame burns through the night, a rebel yell for the righteous fight. Break the chains, let the truth be sworn, from dust and blood a new dawn's born.
Paul Revere is my hero here in America. He exemplifies the First Amendment, not in his freedom of speech, but in everybody else's right to know. When there's danger afoot, you have a duty to speak out. Welcome, Landry. How you doing?
Greetings. How are you?
I am well.
Been a minute.
Yep.
I know that the topic here is very specific to you. I don't really know. I don't have personal relation to it, but I mean, it seems like it's very prevalent to you. I mean, what's the timeline you're looking at?
We just went to eviction hearing yesterday. It's actually called a forcible entry and detainer because we refused to move out in the 3 days they gave us. Of course, that's inherently pretty much across the board. Most people don't. And so they went ahead and tried to move forward with the forcible entry and detainer. And generally they would give a verdict, as Jeeps asked. So what was the verdict? Generally they would give a verdict that day, but she denied the verdict and said she would take it under advisement and get back to us in a week. So we're expecting to hear back sometime next week. And again, I'm assured myself that we will get a dismissal, and then we'll be able to move forward with our civil rights claim. But even if they don't give a dismissal, I'm also prepared with the emergency stay of execution of writ of possession, as well as an appeal.
So you're not nervous at all?
No, I'm not. But that's the thing. My companion suffers from frontal temporal dementia. So she is very, very agitated, emotional, fearful. Yeah, it's an issue, major issue.
Well, man, I mean, if I have heart for you, man. I don't know. I feel sometimes I try at the end of the day, I try to withhold empathy from many situations. Sometimes I feel it. I don't know. Maybe it's undeserved, but time right now. Interesting time. A lot of doomsday people. But are you of the different in society, like in history, that we maybe are not used to, or is this the same old shit?
Yeah,
With
it's
everything going
just,
down. In
yeah, it's
your situation and the greater situation.
Yeah, it's like I expressed with my companion. There's a cognitive decline that happens, and that's what I pose in American society. I think we're going through a cognitive decline. See, the forefathers of this great nation, before there was a public education system, did all of the teaching. And we have to understand that the public education system itself is very new. 1840 was the first public school. All of our education prior to that has come firsthand from people that knew
it's
it.
cutting out a little bit. I think I posted that.
Yeah, we'll see if he comes back. But yeah, that's weird, Jeeps, that a judge not prepared to make a judgment. And that's because I posed a very good argument. If they have a statutory duty to give a 7-day notice of cure upon our complaint, they're the ones that are not following the law. And generally in evictions, the verdict rate for the landlord is higher than the 95% for criminal courts. It's like 98%. Very rarely does anybody beat an eviction. So yeah, they were not prepared, particularly somebody that represents themselves pro se. We went in there by myself. This is all me. I do not trust lawyers and attorneys anymore. No way. No way. I understand the ability to walk into a courtroom and speak the truth. If a man is bound by his word, then why is he speaking the words of another man or allowing another man to speak for him? Woe, ye lawyers, you have taken away the key of knowledge. So again, the principle is, do not believe me. Do not believe the neighbor. Do not believe the government. For crying out loud, do not believe your mother. Do your research so you know. And this is the importance of being able to beat these people. When you know their statutory duty has not been complied with, they're the ones. They're the ones violating the law. And again, this lady's been in property management for 8 years. I can't imagine all the evictions that she's put forth and moved people out of homes unjustly. I can't imagine all the civil rights violations that have just gone by the wind because people handed it over to an attorney and they just said, oh, like a bobblehead. You know, it's fucking amazing. It's fucking amazing. Because that's what I see. But I don't call them bobbleheads. They're babbleheads. Because that's what I hear. Greetings, brother. How you doing today?
Doing good. I got a little late on, I guess your show or your stream, so I was hearing it, and it is the last part that I was hearing. What you were saying is that it's that same thing, right? It's like my people perish because of lack of knowledge. So what you're saying about that, those landlords and doing that to people is that how many they've done it to is that a lot of them are that way. They perish in that situation because of their lack of knowledge.
Yep. And let me read this comment real quick. What if the judge is looking for loopholes to find you guilty and then evict you? There are no loopholes. You cannot. In logic, you have to go 1, 2, 3, 4. You can't start at 4 and dismiss 1, 2, 3. So there is no loophole. I'm going straight to number 1. We gave notice. They failed to follow up with proper legal procedure of giving the upstairs tenant a 7-day notice to cure. That is the issue. Go ahead.
Who, me? No, it's just that what you were saying is how many people get evicted because they just get slapped with an eviction notice and either they leave or they don't know. Yeah, it is. I hate that saying that it is what it is, but I mean, they have to go by that same thing. If you have, I don't know, do you consider that standing upon your part?
Oh, yeah, absolutely. Because standing is really about truth. Okay. And so we have he who seeks equity must come with clean hands. Equity imputes an intent to fulfill an obligation. Equity is a sort of equality, and equity does not aid a volunteer. So when equity does not aid a volunteer, we gave consideration over the last 6 years by paying rent on time, every time, full amount. That is for an equal exchange. Equity is a sort of equality. That is for an equal exchange for the landlord to fulfill their obligation. Equity imputes an intent to fulfill an obligation. Since they failed their obligation and are seeking equity, they have to come with clean hands. But they're coming into equity with hands that are as dirty as my fucking furnace filter. Usus caboose. Do you have any opinion on a historical timeline reset around 1800s related to the Tartarian empires in regards to old world buildings and societies? No, I do not at this time. It is not my area of research. I have done some interesting viewing of various different videos, but I've never done any real research. I know what it's about, but I can't form an opinion on that at this point. It's not really of my interest at this time. But I do understand the reset thing. History repeats itself. And like I said, we're coming up on a time of a reset. That's my inherent belief. When we see things like the ICE immigration issue and stuff, that is getting very close to civil unrest that could possibly endanger a lot of the politicians. And they're becoming aware of that. I hope they're very aware of it. And I'm not pushing for that because I'm a man of peace. Sun Tzu says in The Art of War, to defeat one's opponent without fighting is of supreme excellence. And that's what I would beg people to do. when I went to the eviction hearing, the forcible entry and detainer hearing yesterday, it was nothing like the hearing I had 10 years ago where I was fingering them, cussing them, swearing at them, calling them communist bastards and stuff. I was very well put together, and I made it explicit a point that there's a timeline of events that happen, and you're trying to evict me under a clear and present danger because it was allowed to escalate, and you saw a video where I was very angry, and the neighbors complained that they were threatened because of my anger. You're the one that allowed that anger to escalate like that by not following your statutory duty as a landlord and issuing a 7-day notice to cure for them to quiet down. You knew my companion was disabled, and you knew it was causing her emotional distress, and you moved forward with this forcible entry and detainer with willful wanton disregard for that condition. And you have a duty to know. Ignorance of the law is no excuse, folks. I knew it. Why didn't she know it? She's the professional, not me.
Right. It was actually her duty, I guess, if you can use that word, right?
Well, that's what it states in Iowa. That's what it states. It's a strict statutory duty. And under that Iowa law, when you're evicted within a certain amount of time after you give a complaint, Iowa law presumes retaliation. In Iowa, it's 1 year. So if we'd have made the complaint 1 year, 1 day ago, there would be no presumption. But if we made that complaint 1 year ago, there would be a presumption. We made the complaint December 16th. It was less than a month, and they filed for that forcible entry and detainer. That is absolutely under Iowa code presumption of retaliation. And the court must look at that, particularly when I pointed out that they failed their obligation under that statutory duty to give that notice. And again, just because they didn't know is no excuse. They're the professional. They've been doing this 8 years. They've had plenty of time to research and do and know it. I had to learn it in a matter of days.
Well, yeah, it's just that people are, I don't like the word, but it works, right? It's like ignorant. And it's like, then the lady that it's her duty is just ignorant and acting upon ignorance instead of upon duty.
Absolutely. Absolutely.
And so I think that's why the judge got put in that position, is because I almost want to say they're not used to it, right? They're just used to like the rubber stamp thing, you know, it comes before them, this is the way it goes. People flip or they move or whatever. I'm just really surprised that they were trying to make anybody move in 3 days. You know what I mean? That the law would allow somebody to have to, like, you know, like what you said, they gave you a 3-day, I guess, eviction notice or something. It's like, that to me is outrageous in the first place.
Absolutely. And that's one of those things that, you know, don't believe me, don't believe the neighbor, don't believe the government. For crying out loud, don't believe your mother. Do your research so you know. It's imperative, people. You know, this is systemic, just like the corruption in the politics and the authoritative figures that you have in your own communities. Eviction is a systemic problem, and they get away with it. It does affect everybody. Nobody out there, even though you haven't had firsthand experience yourself, you know friends or family that have been evicted. And I'm assuring you that 98% verdict rate for the landlord is absolutely outrageous. There is no way they can be right that many times. There are several civil rights violations going on in many of these evictions that are just going out the window. Real quick here.
Man up, slaves, and hit those buttons, or I'll send ice.
All right, go ahead.
You scared me. I was trying to find the button to push. It's kind of like, you know, it's like that question about the Tartarian thing, and you said that you're not like really up on that, but it's like, you saying that, you know, that the public education is like something that's really new, but it's like, you know, according to like timelines and stuff, like in our timeline, that may be true, but like in a extended timeline, that may be false. And they've
Yep.
hijacked that public education this time, where they I almost want to say false educate or misinformation in education, because we're not educated in the things that like the position that you're put in and contracts and stuff like that. Is that the public education system now is like, they don't want anybody smarter than to be able to operate a machine, right? It's like they want workers. They don't want almost want to say entrepreneurs, or the ability to govern yourself, rule over yourself. And in the public education that we have in this timeline is be ruled over, sit in your proper spot, be in a row, ask for permission to go here, do this, don't get out of line, don't think for yourself, do what you're told.
Yeah, and it's because of a public education system that I call an indoctrination system. And real quick here, Caboose says, wouldn't that video be simply circumstantial? Where's the context and intent? Always clipping media to paint a picture. Absolutely. And I objected to the entrance of that video for that, because the guy that took the video wasn't at the proceedings. The guy that took the video was the upstairs tenant that I was complaining about. So when they presented that video in court without the proper context, and instead took it as a landlord's context of a clear and present danger that was out of context, and there was no relativity to it, because it was an escalation matter because the landlord negated her duty. If she'd have fulfilled her duty and gave that 7-day notice to cure, that incident would never have happened. It would have never escalated.
See, that's what's strange in itself, right? Is to object to that video, but in some way, that video proved the point in itself, right? I mean,
absolutely. That's what I thought afterwards, that, you know, having that video and knowing that the person that took the video wasn't there, puts it in a context where they don't really know the context. But then when you see the timeline, you can see that event could have very easily been avoided had the landlord done her statutory duty and given them notice, which she admitted that she did not do, and that she did not know that she had to do. And being in business for 8 years, she should have known, and that ignorance of the law is no excuse. That shows willful and wanton disregard. Cindy Ann Ruff says, people took themselves out many times last year in Ohio that were being evicted. Whole families. Terribly sad. And that's why I say I wish more people would come up on this panel and discuss this, because I know I'm not the only one. It affects many people across the board. It is systemic, and there are so many civil rights violations going on. I don't understand why people don't want to stand up. Yeah, the tenants recorded me banging on the wall with a fucking stick. And they call that a clear and present danger. They said they felt threatened. Well, let me ask you. On December 24th, when the police were called for disorderly conduct for that very same reason and the very same actions, how come they walked away without filing charges or even a police report? They didn't even make service notes. And this is one issue I'm going to bring up at City Council now. Because when that officer got on the stand, he wanted to sit there and say, I don't remember what you said. Well, that's bullshit. Because now I have an officer that was there and under his professional opinion, even clarified that he walked away and did not charge me because in his professional opinion, at that point in time, he did not see a clear and present danger. And then when he saw the video, he said, yeah, that looks like clear and present danger. That's contradictory. So when you come out on a police report, on a call, and you whether you charge them or not, you should still have some kind of service notes as to the conversation had, so that if you get called in on the fucking stand and subpoenaed, you can reiterate what your service notes say and why you made that professional opinion to walk away and not charge them. But no, they don't do that. So
that's because they all don't know how to. It's really weird because, yeah, it's the duty aspect of it. I mean, it all in some way relates to the duty aspect of it. You had a duty, you followed it. Nobody else wanted to follow the duty. And it's like you said, it could have been de-escalated from that moment in time, basically, or started a remedy at the moment in time you did your diligent duty, right?
yep. And that's what I was stating before. You know, the first duty in law is legal notice. And if you want to come forth in these courts and make a claim, the first duty in law is legal notice. You have to show that you gave notice. This property manager admitted, without even having to be asked, that she was aware of ongoing situation between me and the upstairs tenant. She was already aware of it. That's because I gave her notice. So she admitted she had notice without having physical evidence of notice other than a text, where she responded back to my phone call about a noise complaint by saying, by iterating a lease term about incidental noise between 7 a.m. and 10 p.m., regardless of the fact that it went on well after 10 p.m. And yes, Jeeps, no body cam.
So, hey, when they got you, or when I guess that the alleged banging on the wall with the stick, was that between 7 and 10?
Absolutely.
That's just incidental noise.
No, I'll admit it was an escalated response to being trapped in a chaotic environmental nuisance of excessive noise. I had already complained to them and the landlord, and nobody did anything about it. So I started banging. You poke a bear, you're going to get a bear.
But how does that make it a clear and present danger? I mean, you were just making noise too, right?
Because he caught me on video with the stick in my hand.
But you weren't hitting nobody.
No.
You weren't threatening nobody. You weren't.
No.
Yeah, so you were just making noise.
Yeah, you can hear me screaming and yelling at him. It's got to stop. You have to stop it. It is bothering. It is excessive. You have to stop. That's all I did. I never threatened him. I never used the stick to threaten him. Nothing. Yes, the sheetrock begs to differ. There's a couple holes. God damn it.
Yeah, I think that everybody should have just followed. That's really weird to say it, but it's like everybody should have followed common sense. But then it comes down to if people would have just followed the law. And
well, yeah, see, that's part of the problem. We have the neighbors are foreigners, 3 adults, 3 children in a 2-bedroom apartment. Now, I know the old adage, and most of us are aware of it, children are to be seen and not heard. That's because we don't allow them to use the interior spaces of a dwelling as a jungle gym, running, stomping, jumping, hollering, screaming, yelling. No, you want to do that shit? Go out back, right over here. There's a fucking school playground. Take your children to the playground.
Absolutely. Especially in a dwelling that is, you want to say, a multifamily, right?
Absolutely. Fair housing because it's subsidized. It's low income.
Yeah. There you go. So I can see that. I mean, I think it's great. I mean, whether the judge did couldn't rule or make a judgment at that time is like, I still think that's like a good thing.
I do too. Because it's going to it gives me time to go down to the Fair Housing Authority down here in Waterloo tomorrow and speak to them about filing my claim. And then, of course, we had a viewing of a house today. A house. We can't get into an apartment anymore. We have to have a single dwelling house because of the noise issue. And we are willing to take on the maintenance of snow removal, lawn care, and furnace filters in exchange for that, because I'm fully capable. You know, I'm willing to do that. But in multi-housing units, no, that's a maintenance issue for the landlord. See, in a multi-dwelling unit, if you place the tenants responsible for changing that air filter, that furnace filter, and if one tenant refuses to follow that lease term and does not change it, it is a safety and health risk to the rest of the tenants. That's why the landlord has that maintenance responsibility, because then they have a work order that follows a regular schedule and a record keeping of that.
Right, because you don't put it in the hands of your residents whether your building burns down or not.
And Oos Caboose says, come on, Wiz, children can't be contained that easily. Rambunctiousness is in their nature. I understand that. But when it's all day long, every day, and well past 10 o'clock, that is way too much fucking sugar. You understand me? Don't sit there and play this fucking cognitive dissonance that you're going to side for them because they're children. It's not a children issue. It's an adult issue who allows their children that rambunctiousness inside a dwelling affecting other people in regards to that noise issue. All day long, well past 10 o'clock. No way. Right, I made a reasonable request to quell the noise. We can understand incidental noise, but all day long, well past 10 o'clock is obsessive and excessive. And that's our claim, because it does affect my companion's stable mental state. She gets emotional if she can't get her naps. She gets emotional if she can't get to sleep at night because of them. This is affecting our lives materially and very distressful for her. And of course, like I said, I'm the only one she can take anything out on. So it comes on to me as well as extra stress. I don't need to deal with this. The landlord should have given the 7-day notice to cure, and that should have been the end of it. Instead, it allowed it to escalate, and both of us are being harassed by it. And willful, wanton disregard is no excuse.
Yeah, because I was thinking that's too much sugar in more ways than one. That's too much sugar in their diet and then too much sugar emotionally, is because children are children, but children still have their place, right? And if you can't teach that or be responsible.
If you come from the sub-Saharan desert where you live in huts, you don't live above people. Yeah, you can let them run around all day long and past 10 o'clock in your house. But when you live in America and you live in a multi-unit complex where you're above somebody else, you have to have the restraint. And just because you're not familiar with American culture doesn't mean you don't have to abide by it. It means, just like the landlord, you should learn the laws and live accordingly by assimilating to that fucking culture. This is one of the problems I have with immigrants. If you're going to come to America, you have to assimilate to our culture, which means there's a lot more legal restrictions that you have to abide by. You can't just use the same excuse. Hey, they're children. No. That's no excuse. We have laws here. You better learn them. And yes, that's one of the reasonable accommodations we requested. If you can't quell their noise, move them to another building or a downstairs apartment where it's not affecting us. We asked for reasonable accommodation even after our notice, and they ignored that. Upon their eviction, we sent them a request for reasonable accommodation to do so. And they ignored that too. Again, a violation of Federal Housing Authority Code under the ADA. A reasonable request for accommodation when it comes to a person with disability cannot be ignored. And they ignored that too. Another strict statutory duty. Yeah. So anyway, yeah, I'm kind of heated over it, but yeah, I'm assured that we're going to win one way or another, whether we have to appeal it or whether she comes back this next week granting us our dismissal. And so that's why I read the documentation earlier. And like I said, I got 10 more pages of notes in preparation.
But you don't think it'd just be a dismissal, right? Do you think you'll be granted that What was it you just said? A reasonable accommodation? You don't
Well,
think you'll be granted that?
well, no, if they dismiss, then they have to go forward with that accommodation. They have to remove the other tenant. Okay. So that's their problem, not mine. So when I go forward, it's just a simple civil rights claim now. Unless they grant the verdict to the landlord, then I've got the emergency stay of execution of writ of possession and an appeal ready. I've already got them ready.
Okay, what I want to ask is, because I don't know, right? So I'm going to now blame myself for being ignorant and use that. Is that couldn't a reasonable accommodation? I mean, if that's, I think if you said Section 8, then Section 8 also has single family residencies too, right? So even in that moving forward, being granted that reasonable accommodation, maybe that can be used to place you and your partner into a single family.
Yeah, but I wouldn't do it with the same landlord. No fucking way. We're moving whether we get the dismissal or not. We're moving. We can't deal with bad faith motherfuckers. Been doing this 8 years and don't even know the fucking law. Ain't no way I'm going to stay any further. They can fuck somebody else's life up, not ours. And Cindy Ann Ruff says, so were you in district court since it was federal? No, it was municipal magistrate court. So now I appeal to the district court. And if I lose there, then I appeal through a certiorari to the state Supreme Court. So anyway, I think I did a pretty good job. And if anybody's got any suggestions, I'm always open to them. I'm not going to be so big headed. But again, like I said, I'm assured that we're going to win one way or another. So we'll figure it out. Well, that would depend. She says, aren't they due you accommodations for a year? Again, that's what the punitive damages would be. We're going to punish the landlord and we're going to get $6,500 and that'll help us pay rent for another year at a new place. Plus we're going for $25,000 for actual damages. And by the time it's all over, depending, I might even move that up. Iowa's had $3.25 million claims. Of course, there were sexual events in there in those cases, but even $25,000 is very minimal. $100,000 is probably what I'll ask for, and then they might say, well, that may be too much and drop it some. But right now it's set at $25,000, and I'm still, debating. I might just go ahead and move it up to $100,000 just to, put it at a max state. I'm one of those very reasonable people, and I think it's conducive to my good nature. But at the same time, like you said, you poke a bear, you should get a bear. So I'm not going to be so fucking nice about it anymore. And yes, they admitted to their not knowing their own regulations, then they should be held liable. And that's the whole point. That's the foundation of our claim. They had a strict statutory duty to give that upstairs tenant a notice to quit. And if they didn't, that was the cause of the escalation to where they're using clear and present danger against me. If they had given that notice, it would not have escalated. I would not have been out in that hallway with that stick in my hand, hollering and screaming. So anyway, you got anything else on the way out, brother? We're going to end this. All right. Well, I appreciate your presence here. Thanks for coming up and discussing things. And you guys, you bet. You too. And you guys know me. I love you, but I don't give a rat's ass whether you love me back. That's on you. So may God bless you and have a good night. Enjoy it on the way out. Oops, wrong one.
Hold up, grab my soda cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got the smell, you know, like grape pape. We ain't talking vapes or the color of drapes. Or a gorilla in a cape is the good shit. Just one hit, you so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation, with gross castration, skewed citations by your intimations. Get real, young man, there's only one stand. You can't stand a suntan, how you gonna live on the land? Obliteration of the carnation, with gross castration, in skewed citations by your intimations. I'm a truth in rotation, you're a cheap imitation. Darks and hums, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in a cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna clank another hit of this good shit, and I'm already it, so take over this bit, non-bit.
Thank you for joining us at Personality Inventory Mockumentary Production.